speak. I would like to introduce to you our presenters today. We have Paul Sherman, Compliance Consultant from Wisconsin Department of Public Instruction. Paul is going to give an overview of IEPs, 504s, and service plans. He's going to share the difference of those plans, and you'll have the opportunity to ask questions. Sally Flashberger is the Lead Advocacy Consultant for Disability Rights Wisconsin. She is going to speak from a parent advocacy perspective and share what parents can do if they are having issues and what people might expect parents to be doing. We also have Colleen McHugh-Moore with us. She's the Special Education Director from Greendale School District, and she's going to help us put things into practice. She's going to speak on how decisions are made and the policies and processes that you follow. Our webinar objectives: explain the difference and similarities of these three plans. Participants will hear from a variety of perspectives, and participants will learn about the resources to share with families who have a child with a disability and school staff who work with them. And we are going to begin with Paul. Okay, I would like to say that my slide screen here actually went blank. Is anyone else seeing that?
I'm seeing it blank too.
Okay. Okay, I wonder what happened. Okay, there we go. Okay, thank you.
All right.
And Paul, you may start.
Thank you. Good morning, everybody. I'm glad that you came in on such a lovely September day to learn some more about this topic. My intention really is to give a very broad overview of IDEA and Section 504, as the title of the slide says, the basics. Particularly for 504, the handouts that we have provided for you are excellent resources and things that I frequently share with parents if they have questions about 504. So I will try not to get too deep in the weeds today and just give a broad overview of things, and we'll go on from there. You're probably all quite familiar with IDEA, or the Individuals with Disabilities Education Act, which dates from the mid-1970s. I think it's important before we start just to realize that Section 504 of the Rehabilitation Act is actually older than IDEA. It's a predecessor to IDEA, and it also has broader application. While IDEA generally applies in the birth to 3 on up through the end of the 12th grade, or students who stay around longer until age 21. Section 504 is also a law that applies in all other types of educational programs in the United States that receive federal financial assistance. So Section 504 applies generally at our technical schools, our 2-year schools, as well as our 4-year colleges and other types of educational training programs. So if we can move on to the next slide, we'll get started. In terms of eligibility, IDEA is, a student is eligible for IDEA if the student meets criteria in an eligibility category and is in need of special education. That's the 2-prong test that I'm sure we're all quite familiar with. The Section 504 eligibility is a broader standard. There, the student is eligible if they have a physical or mental impairment that substantially limits one or more major life activities. And as you can see from looking at that definition, that's quite broad. It's any physical or mental impairment, and then we look at substantially limiting one or more major life activities. So that can be standing, walking, seeing, hearing, and importantly for us in the educational context, learning is also considered one of the major life activities. Next slide, please. For evaluation under IDEA, we do an individualized education program team conducts the evaluation. For 504, it's a group of persons with knowledge, both about the student and about the educational program at the district. One of the interesting things about 504 is that there really aren't the type of detailed policies and procedures existing under federal law for 504 that there are for IDEA. So the guidance that the Office for Civil Rights at the U.S. Department of Education frequently puts out is if you're essentially following IDEA policies and procedures, you're meeting the requirements in conducting a 504 evaluation. So that often means that something that looks very similar to an IEP team that conducts the 504 evaluation. Next slide. In terms of providing services under the two laws, IDEA, we provide special education and related services as specified by the student's IEP team. Under 504, the services are appropriate educational services designed to meet the needs of the student to the same extent as the school meets the needs of students who are not disabled. So the focus on IDEA is what the IEP team thinks the student needs to make educational progress. The focus under 504 is getting the student equal access to the educational program. Next slide. We specify that under IDEA, of course, in terms of the individualized education program. Under 504, we have what's called a 504 plan. Now, again, under 504, we don't have nearly the detailed requirements that we do under IDEA. So, in fact, a 504 plan doesn't really even need to be written according to the regulations. It can just be the team decides what the student needs in terms of accommodations to have that equal opportunity to participate, and that's what's provided. Sometimes that gets written down. In fact, that's probably a good practice to have that written down in a 504 plan. Next slide. We do have the requirement under IDEA that we conduct a reevaluation every 3 years unless it's agreed that one is not necessary. The requirement under 504 is that the reevaluation be conducted periodically. Again, if districts generally are following their IDEA requirements to meet the 504 requirements, that's probably every 3 years under 504, but it can be more frequent, it could be less frequent. Okay. If we have disputes that arise under IDEA, of course we have the mediation system, we have the state complaint system, and we have due process available. Under 504, all school districts must have a grievance procedure, it's called, and that's sort of an internal way that disputes can be resolved. Districts are required also to offer due process, but unlike IDEA due process, the Department of Public Instruction does not operate the due process system for 504. Districts are actually required to set up their own due process system whereby they hire the independent hearing examiner and provide the procedures for that. Parents can also, go back if you would please. Parents can also file a complaint with the Office for Civil Rights at the U.S. Department of Education if they have a concern about Section 504. The Office for Civil Rights generally does not actually review what 504 teams develop in terms of 504 plans. They will only review whether the district has the appropriate policies and procedures in place. Now we can move on to the next slide. When we're talking about IDEA for private school students, we need to recognize that the child find and evaluation requirements for students who have been placed by their parents in private schools is the same as it is for students who are attending public schools. Private school students are entitled to what's called equitable services, not a free appropriate public education. The students attending private schools get their services through a services plan, which is developed using what the regulations describe as the IEP process, where appropriate, but the services plan is not an IEP. In other words, it's not an individual entitlement. It's just a description of the services that will be provided to the student. And a services plan should only specify those equitable services. So sometimes we get questions here at the department as to whether a services plan should describe the services that the private school is providing to the student. And the answer to that question is no. Next slide, please. If a dispute arises about a private school student, the state complaint procedures are available to parents if they have a concern about the implementation of a services plan or the way the service plan was developed. And the due process procedures are also available, but only in terms of child find questions. Because there is no individual entitlement to FAPE for students who are in a private school and receiving services through a services plan, the due process procedures are not available to resolve disputes about what's appropriate in terms of a services plan. Next. Okay. Section 504 for private school students. The general rule is that 504 requirements do not apply to private schools. So private schools do not develop 504 plans for their students, because generally the private schools that exist in Wisconsin are not recipients of federal financial assistance from the U.S. Department of Education. Okay. Public schools have no equitable services requirements under 504, so they are not going to be serving students who have been placed by their parents in private schools under any type of 504 plan. That would only be equitable services under IDEA. Sometimes we ask whether public school districts are required to evaluate students for eligibility under 504 if the student is attending a private school. And to be honest with you, I've gotten two different answers with that from folks at the Office of Civil Rights. So I usually recommend that if a district or a parent has a question about that, that they contact the Office for Civil Rights directly. Next. Okay. For students who are in a home-based education program or homeschooling, there are no FAPE or equitable services requirements. The child find evaluation requirements do apply, so if the student is in a home-based education program and the parent wants the child evaluated for eligibility under IDEA, the district does need to conduct that evaluation. 504 does apply if the student is participating in a public school program. There are some options available for homeschool students to participate in district extracurricular programs or to take one or two classes at the public school. If the student and the parent elect to do that option, the district does have an obligation to meet the student's disability-related needs under 504. Participating part-time in those types of programs does not give the district an obligation to meet the student's needs under IDEA. Okay, we can move on. So for questions about IDEA, you can certainly contact us here on the special education team. I can provide limited answers to 504 questions, but DPI doesn't have the ultimate responsibility for enforcing Section 504. So we usually hand people off to the U.S. Department of Education Office for Civil Rights, and they have a regional office in Chicago, which covers Wisconsin, and the phone number is available to you there on that slide. And I think that brings me to the end of what I wanted to say, so we're happy now at this point to take questions you might have.
Okay, are there any questions for Paul regarding IEP, service plans, or 504 plans? You may ask now. You can either type it in or we can unmute you and you can speak your comment. And Evelyn, if you see anyone asking a question that I can't see from my screen, let me know and help navigate me through that part. But currently I don't see anyone with a question. Okay, so if there are no questions, thank you, Paul, for your presentation. It was very helpful. And then we could move right along to Sally.
All right, thank you.
All right, great. I am unmuted, I think. I don't see my slides yet, so I'll kind of wait for you to catch up.
Yep.
I'll introduce myself. I'm Sally Flashberger. I am a special education advocate with Disability Rights Wisconsin. I work in our Milwaukee office, and I've been here almost 9 years. I am also the parent of a young man with a developmental disability. He's 22, so he went through public school in Wisconsin for his entire career. I at one point was a parent liaison, when that's what we called that, for my own district in Elmbrook, and I loved that. That was kind of my foray into actual paid parent advocacy. So today I'm going to talk from the perspective of a parent advocate. Rita, if you want to advance the slide. So I'm going to tell you a little bit about disability rights first. We are the protection and advocacy agency for the state of Wisconsin. So every state has what's called a PNA, and we're charged with protecting the rights of all people with disabilities. So we do a lot of work with kids. I would say the majority of our work is a lot of education advocacy. But we also work with adults, and when there's rights violations or access to services. We have 3 offices. We have Milwaukee, Madison, and Rice Lake. So we do try to cover a pretty wide area of the state. You can always contact us through an 800 number to ask questions. Even if a parent, you can refer a parent to us, but if you have a question, you're able to contact us also. We focus on, what I would say is we kind of focus on the most egregious issues for kids because we do have limited resources. We have to set priorities every year, and we actually are doing that now. We always do that around this time. So our 4 priorities that we work on are exclusion from school. So that could be suspension, expulsion, shortened day, placement in segregated settings, different things like that. We work on seclusion and restraint issues. So if parents are facing inappropriate restraint, overuse of seclusion and restraint, and we also work on this from a policy issue too, hoping to look to the future to how we can make the law better to protect students. We do some work around least restrictive environment. Generally, that's if we see maybe a particular school district going to more restrictive placements where they're creating more segregated classrooms, and parents are calling us about that, we might get involved. And then we look at transition services. And so if students are not getting appropriate transition, or if we are finding maybe they're exited early before they've maybe completed transition. And we do a lot of training around transition and informing students and parents about the post-secondary transition plan. Next slide. So I'm going to kind of look at IEPs, 504s, and service plans from resolving disputes. And so I'm going to kind of step through each of those. So these are kind of the areas I'm going to talk about, is each of these ways that a parent can have a dispute resolved, starting with the easiest to the most difficult. Rita, you can go forward. So we always encourage families when they call us to really look at starting with the person closest to them. We get a lot of calls that don't fit our priorities, so we're often giving a lot of technical assistance. So we always encourage people to talk directly with the person involved, the special ed teacher, or maybe the related service provider. Sometimes just scheduling those informal meetings can really resolve a lot of issues. We always try to tell parents to write down their list of concerns, because sometimes when they get in a meeting of any kind, they get nervous or it's emotional, and it's best if they maybe have a list of that. Parents often will send an email to be sure that they're getting those questions answered. I say appropriate email because I think a lot of times we know that things can get personal in email because it's a lot easier to write some of those things down than to say them in person. And we also see sometimes parents who just email all the time. And so we try to help parents think about, what's the most effective communication. And we always try to talk about don't jump to conclusions, really go in there with an open mind and figure out what maybe is going on for your child. Next slide. So so this to me really starts more of the formal options. So, when we get involved, we definitely want to have an IEP meeting. It's very rare I would go to an informal meeting because if it's gotten to the level of needing advocacy, there's probably something that's going to need to be changed in the IEP. So, so when parents are really talking about something that might need to change in the programming, it probably is best to schedule an IEP meeting to discuss those concerns. We try to work with the parent to maybe write down those concerns ahead of time so that, again, they have them and they can really focus on what the issues are, not to kind of like a business, really have those problem-solving issues out there. Maybe agree on an agenda ahead of time with the school because I think IEP meetings are sometimes can not be, nobody wants to be there 5 hours. So what are we going to discuss today? What's going to happen at the meeting so that you can clearly get the situation resolved. And then try to just eliminate the things you can't change. You can't really change somebody's personality or you can't really change, maybe a service delivery or, but try not to worry about those things. Next. Next slide. So this is one area that we often don't see a lot of parents access, but which is facilitated IEP. And so we often, especially if we're not going to take a case for a parent, we might encourage them to use a facilitator for an IEP. While that's not necessarily an advocate, it really is a great model and really having that neutral person in there to help people get through the IEP process and make sure that each side is listened to. I think it's just as useful for schools to look and use that as it is for parents. Because I think oftentimes maybe they've gotten to the point where the conflict continues to come forward and they can't really come to they can't finish an IEP sometimes, they just keep meeting. So I encourage schools and parents to use this, the facilitated IEP. It generally is limited to 3 hours and they do use the mediators from the mediation system to help to complete the facilitated IEP process. Next. So mediation is one of my favorite that we use for families. I would say a lot of the time, by the time they get to us, things have really kind of degraded and aren't really going well. And I think that it is a great alternative to filing due process. We'll talk about due process a little bit, but that is not the preferred activity of any advocate or even an attorney. Sometimes mediation is when the parties, they really want to come to some type of agreement, but the trust has maybe broken down. It does sometimes repair those relationships, and you will, parents and schools should come out of that meeting with an agreement. So that would be a signed contract between the school and the parents. There are oftentimes when I have parents who participate in mediation without help, and they maybe come to us because things didn't go well even after the mediation. And generally I find out that there was not a signed agreement. And I think this is a protection from for schools too, because because I think that often, you know, if you don't have something in writing after you go through a process like that, you know, parents may come back and expect more, and schools may come back and say, we didn't agree to that. So I think being sure that the mediation ends in a signed agreement between both. These services are free of charge. Both parties do have to agree to mediation, so the school and the parents have to both sign a form and agree to go to mediation. But I think it is one of the most effective conflict resolutions in our state. Next. So independent educational evaluation is another way under an IEP to kind of resolve an issue. This is generally when a parent disagrees with an evaluation. Usually it's that initial evaluation, but it can be used in other instances within the IEP, possibly a reevaluation, or a functional behavior assessment can also be considered a evaluation. So parents are able to request an independent educational evaluation from the school. They should do this in writing, of course. The district it needs to have policies and generally a list of examiners to provide to the parents. Parents then can get that IE, and it is at the expense of the school district. What happens then is the IEP team has to consider the evaluation. It's not a slam dunk that things, you know, that the student is going to be found eligible, or a new functional behavior might be, a new behavior plan might be written. It's really, it has to be considered by the school district. But it is a good tool for parents who really feel like their child maybe did need special ed. Next. So state complaints. Obviously, any parent can look at filing state complaints. It has to be within a year of the alleged violation. And generally, these really are looking at the procedural issues. You know, it's not a lot of, I mean, I guess I would say it's not a lot of like quality of education, or so it's real specific. So like my example is, you know, the OT goes out on medical leave and the school district doesn't replace that person, and the child goes without services for 6 months. That's pretty cut and dry. We file a lot of state complaints around seclusion and restraint when we see that maybe there wasn't proper notice, or if there was inappropriate restraint to the child. Oftentimes too around suspensions, if a child's being what we call de facto suspended, and I'll talk about that a little bit later when we get into some of the issue areas. But the complaint does have to be decided within a 60-day time frame, and basically if the complaint can come back and tell the parent, yes, there was a violation, and then DPI may give specific corrective action, compensatory education. Those are things that the parent might get from a complaint. Next. And then our least favorite is due process. This really does need to involve attorneys. When parents call and talk about filing for due process themselves, I really discourage that. I think parents sometimes think this is going to be a really simple process, and it is very difficult. Parents generally need to have an expert who's going to testify about whatever the complaint is about, because the school district will be there as an expert in the school arena, and the parents need an expert themselves. This would really be a last resort. Some of the areas that we might do this on is maybe a placement change to a more segregated setting, and so the student has the right of stay put, meaning that nothing can change once you file due process. I think the best thing about, you know, due process does also require you to go to a resolution session before a hearing. So, so in the realm of our work, we would maybe file this if we had to stop a change of placement. That's generally when we would file it, but then we would try to go to mediation or resolution. We have not participated in an actual due process hearing, I think, for over, I think it's been 5 years since we actually had to go to hearings. So that's good. And there's very few in the state, maybe 3 a year total. So considering all the kids we have, a lot of our other resolution options are working well for families. Next. So, so 504, can you go back one, Rita?
Yeah, absolutely. It's been a little temperamental.
Okay, no problem.
Thank you for understanding.
No problem. So, so 504 has, they have different options for resolving disputes. I think that trying to stay within the informal and the formal and not going to the Office of Civil Rights is better for parents. Next. Oh, did you, is that right? Okay. That does, okay, that
Should I go back one?
Wait, let me look. I have my slides in front of me, so let me just look.
Okay, okay.
Oh, no, that's where I have it. Okay, so let me just talk about informal and formal. So informal, just like the other, holding that, you know, trying to have a meeting with the school to discuss the issues. Okay, go back.
It is jumping on its own. It is. Okay, let's try this again.
Okay.
From current slide. Okay, we're starting here, correct?
Okay, that looks good. Okay, great. Okay. So I think trying to have that informal meeting, often what we might see is maybe accommodations aren't being put in place in a particular classroom. The 504 plan talks about what a teacher needs to do. So really working with maybe who the coordinator is within the school. Sometimes it's the school psychologist, sometimes it's the social worker. You know, it's generally not it's not going to be a special ed teacher. So, you know, maybe going to that person and saying, hey, so-and-so teacher isn't giving my kid extended time like the plan says. So I would always start with the informal. And then obviously having that formal 504 meeting. So if it's really become an issue and you feel like your child's not getting those accommodations, that's what we would say is sit down with the entire team, maybe review the 504 plan, talk about what is working and what isn't working. I've seen in some districts, which I think is a really useful tool, that kind of quarterly, like when they have report cards, there's kind of a report that talks about, you know, is the student accessing the accommodations? Are the accommodations successful? And teachers reporting out whether there are other accommodations that might be needed. So while not required, I think it would be a best practice for a lot of school districts to be really kind of looking at that quarterly reporting to be sure that a 504 plan is working. Okay, Rita, you can go to the next one if it works. All right. So the other option is to file a OCR complaint. So with the Office of Civil Rights, it has to be filed within 180 days of the violation. So say a student doesn't get their accommodation, the parent has that 6 month, 180 days to file that. You can do that online. You can go to the Office of Civil Rights and you can file it online, or you can send the written complaint. Generally, what we would do is send it directly to the OCR office in Chicago. Like Paul had said, generally in the eligibility process, Office of Civil Rights will not look at whether the student should have been eligible for a 504 or not. They're really going to be looking at was there a violation of the process? So did they not provide parents with their rights? Did they not consider something, you know. So it's really going to be more procedural, not whether or not the student would be eligible. That would really have to go through more of a hearing process. And then the other complaints is that that, you know, you're really asserting that there's discrimination because they're not providing a service. So so parents whose children have 504 would maybe file a complaint because the child is not receiving their services. Next slide. So what happens when a parent does file a complaint with OCR? Well, usually the first thing that happens is you can go through what's called the early resolution process. This is a process that allows families to work with the school district and like a mediator to come up with a resolution before any investigation happens. I always encourage parents to choose that process because sadly a full investigation can take over a year. I can tell you right now, we don't file very many Office of Civil Rights complaints because we don't see it. The process is very long, and then often it really doesn't give the parent what they need or what they're expecting. I can tell you that I filed a complaint last year at this time, and they still have not made a decision. And we tried to go through early resolution after a period of time, but we weren't able to come to an agreement. So it is not a process that I look forward to as an advocate, and I think it can be very difficult for parents. So I would always encourage parents, if they're going to use this process, to do the early resolution process first with OCR. Next one. So service plans, we don't do a lot of advocacy in this area. We do get a lot of calls and questions from people whose children are in private schools. Since we're in Milwaukee, we get a lot of questions about kids who are in voucher schools, usually around discipline and issues relating to exiting kids out of private schools due to behavior issues. But if you think about a service plan, like Paul was saying, it really is about writing kind of what services the district can provide to the private school student. So the rights are very similar, meaning that you can have an IEP meeting, you can go to mediation, you can file a complaint, you can go to due process, but it's very limited what a parent would be able to get from that. So it's not really a situation where you're going to use those tools, even though they're available. I think the most important thing for people to understand if they are possibly leaving the public school and choosing a private school is that, you know, special education services are not required, and it's going to be very small, equitable services that are available. And I think that's really where, as an advocacy agency, we try to make sure that people understand that, you know, kind of that giving up of rights when their child is attending that private school. Next. Okay, I talked about that, so next. Okay, so what I wanted to do was kind of give you some of the common issues that we run into for IEPs and special ed and 504. So often some of the common issues under evaluation is parents may be told that they should wait, that they shouldn't do an evaluation yet. Parents often do not submit the requests in writing, which sometimes then it doesn't happen. That's very often what we find is parents have not asked for the evaluation, whether it be special ed or 504 in writing. And then, you know, we definitely have schools that say they don't do 504 plans. I'm not sure why people don't want to do them, but we definitely do see that, and that they do what they might call a some other plan. Sometimes they have their own names for them. So I always encourage parents to go through the process. Next slide. So here it just gives you some answers to this issue. I think I heard Paul say that too. It's really a good idea for students to go through the whole IEP process, even if the parent is just requesting the 504, because the school really has a duty to be sure that the child does not have a disability that needs special ed services. So again, I think it's very important that parents do the whole thing and not just say, oh no, they just need some accommodations, because you never know, you just don't know. And as I said, it really needs to be in writing. Parents should list the issues that they're seeing with their child. And when a parent makes that referral, the school district does have to do the evaluation. Next. So common issue number 2, not following the plan, whether that's an IEP, a 504, or a service plan. Again, we don't really get a lot of calls about the service plan. So parents say, sometimes school districts say, well, we just don't have the money to provide that service. Next slide. So obviously schools must provide all services in the IEP. A very simple way, if parents really can't get them to provide the service, is to just file that simple complaint. Schools can't change the IEP without a meeting or without written agreement from the parent. So if parents think something may have changed in the IEP, it's really not allowed. School districts really can't say they don't have the money. I mean, it is possible they don't have the money, and that it can be a budget issue, but they're really just not allowed to say that. And parents really need to look at how that service can be provided and work with the district. Districts do have to kind of figure out how to pay for that or how to provide that service. And then again, we talked about 504 and how often, if accommodations aren't being provided, parents can file those complaints. Next. So parents come to us often and say, well, my child isn't making any progress, they're failing their classes, they can't read. Those are really, a lot of calls we get are around these issues. Next. So what we encourage people to do is to really go back and look at their child's progress, ask for the data. So, not the anecdotal, the real data, whether that's standardized tests or information, maybe it's math testing, or even asking for that. Often when we see students struggling like that, we might ask a parent when the last reevaluation was. And sometimes it's been waived once or twice, and maybe it's really time to get that reevaluation because something isn't working, and maybe there's something that's being missed, and that will give data for the parents. We talk about parents trying to understand what the interventions are that their child's receiving at school, and to be able to get the data that shows that progress. And if you really feel like that intervention has been done with fidelity and the child is still not making progress, and this could be academic interventions or behavioral, then really, maybe it's time to change that intervention. And then holding that IEP to make changes to meet the needs of the child. Next. All right, so this is a pretty big issue for us. We deal with these calls all day, every day. We probably get calls about suspension. So schools, people call because their child's being suspended due to their behaviors related to their disability. Parents call because The child is being sent home all the time for behaviors. Often parents aren't sure if their child has a behavior plan, or possibly they want to reduce the child's school day due to the behaviors. Next. So schools can suspend students with disabilities for up to 10 days before they have to do manifestation and all of that. So often we have parents who call and, you know, they are saying, my child got suspended for 2 days. They can't do that. It's because of his disability. And, you know, we do clearly tell them, yes, they can, schools can do that, you know, but let's look at the reasons and see what's going on. Very often we have parents who call that schools are sending their kids home without a suspension. So a behavioral issue arises, the student is sent home, there's no suspension. This would really be considered a de facto suspension. So in these situations, you know, I've definitely seen this go on quite a bit in some school districts, and the child is being sent home weekly, if not, you know, multiple times a week. And so they're really missing instruction, and it's not changing the behavior. So when suspensions arise, we really encourage parents to be talking about, you know, has my child had a functional behavior assessment, and is there a good behavior plan in place? If there isn't, then that's a starting point. If there is, then it probably needs to be revised. The other thing we see is that reduction of a student's school day due to disability. I think DPI, it's probably 2 years ago now, but they really did come out with good guidance for school districts and parents around shortened day, and really talking about how behavior is not a reason to reduce a student's school day. So often I think, you know, it sometimes is everybody needs kind of a cooling off period, but it doesn't really change the behavior. And so I always point parents to that guidance if we are not going to be assisting them. Next. All right, so we get these calls, my child's about to be expelled, or my child has a hearing or a pre-hearing conference or a administrative hearing, all sorts of different school districts do different things. So we hear a lot of that. Next. So children with an IEP and a 504, I think this is important. A lot of times school districts do not necessarily understand that a 504 has the same protections regarding manifestation determination. So if a child has an IEP or a 504, manifestation determination must be conducted before they would go to expulsion, because expulsion is considered a change of placement. So a manifestation determination says that the children's behavior was a direct and substantial relationship. Oh, I'm sorry, that should say to the disability. We always encourage parents to bring, whether it's if a child has a therapist, bring a letter about the behaviors. Parents can bring in information about a child's disability and diagnosis. It is not specific to just the disability listed in the IEP, because there can be, you know, we only have those 8 categories or 9 categories. So there can be other diagnoses that should be brought forward from a parent if it's not something that's captured in the IEP. If the behavior is a manifestation, the child cannot be expelled. They have to then revise the behavior plan or create one if there isn't one, and the child remains in that same placement. This is one of the only areas where a parent absolutely has some authority here. So if it is a manifestation, a parent and the district have to agree if there's going to be a change of placement. So the district cannot force a change of placement after a manifestation determination. It has to be an agreement between both parties. If it is not a manifestation, the district can proceed with the expulsion. And the only way that that would be able to be stopped is if the parent were to file due process in regards to whether it was a manifestation or not. And so sometimes that is another area where we may file a due process if we felt the manifestation was not correct. Next. All right, so seclusion and restraint, child secluded or restrained at school. The police may have been called on the child, or often the cases that come to us is when a child has maybe been hurt due to restraint. Next. So obviously, only trained staff are supposed to restrain or seclude a student. We do know that in an emergency situation, so say the child is running out the door and that trained staff isn't there and they're about to run into, traffic, personnel would be able to restrain them, but going forward, it has to be discussed. The school has to report the restraint or seclusion to the parent within 24 hours. And then they have to prepare a report within 72 hours. And the parents, the reports are not given to the parents. The parents have to request the report. So often we see parents will call about inappropriate seclusion or restraint, and they've just been told that this happened, but they haven't gotten the report because they didn't request it. So so again, they have to request it. Again, if there's no behavior plan or positive interventions in the IEP, that needs to be included. Children can only be restrained or secluded for danger to self or others, not for non-compliance. I think we're getting better with that in our state. They cannot use mechanical restraint, and the law says care to head, neck, and breathing. And basically it does mean that they cannot use prone restraint where they put a child down on their stomach. Schools, we do get calls from parents who are upset that the school has called the police on their child, but there's nothing to prevent that. School districts can call the police, and the police are allowed to use a different level of force. But the law does say that if the police restrain a student, the school district still has to create a report for the parent. And then if the student is injured, we sometimes suggest that parents contact Child Protective Services just to be sure that it wasn't an issue of abuse happening at the school. They're the best people to make that decision. Next. All right, so I'm at the end, and I do see some questions, but I don't know how we're going to do that.
Okay. So we have a few questions here. Okay, so let's start with this one. It says, should districts have a special ed teacher as part of 504 plan?
No, they do not have to have a special ed teacher. So a 504 plan is really about accommodations. And so, generally you're not going to have a special ed teacher. You'll have a regular ed teacher. It just, again, when you're in the evaluation process, it depends. If you're going to start with a special ed evaluation, then yes, there will be a special ed teacher involved. But if you strictly move to 504, it's generally going to be regular ed teachers, possibly an administrator, maybe a school psychologist or a social worker, depending on what is needed. It might be the school nurse you know, for kids who have diabetes or severe allergies. So really special ed is not supposed to be involved in that 504 process. Anything else?
Yep, there was a couple of other questions. If a parent wishes to change placement minutes in their child's IEP, do they, you know, like add another 30 minutes of recess time, something like that? Does the whole IEP team need to meet, or would a written request change suffice?
So I guess I would not consider that a change of placement. So a change of placement might be like a change to a different school. Sometimes it really depends on the level of change. So I know that's not really a good answer, but say like your child needs an additional accommodation of some extra time. Generally that can be discussed, that can be determined without holding an IEP meeting, and a form has to be filled out. But if you're talking about adding services, changing from maybe being in the regular ed setting to the special ed setting, that's usually going to have to be the IEP team. It does not necessarily have to be the full team. It has to be the special ed teacher, a regular ed teacher, and the LEA. If you're not discussing changes to those related service providers, then they don't necessarily have to be in the room to make that decision.
Okay, we have another question here. It says, how can a parent access an IEP facilitator?
So that is through the Wisconsin Special Ed Mediation System. And we could have that, we could probably get that up or posted. But if you just Google Wisconsin Special Ed Mediation System, that will come up. And so they set up mediations and facilitated IEPs. And so you'll see that on their website, and there's a form there. And again, that is a process where both the parent and the school district have to agree to that facilitation.
Absolutely. Okay, it says, when parents want outside evals, does schools pay for it? Should school have a list of evaluators, and does school have to accept outside evals?
Okay, so yes, if they, so first, the district has the opportunity for that outside evaluation, okay? So that's really important. We have a lot of parents who call and say, oh, I just want to get my own evaluation. No, it doesn't work that way. So to get that independent educational evaluation, the parent has to disagree with the district's evaluation. And then at that point, they are allowed to get one outside evaluation, so one IEE. It has to really be focused on, similar to what the district did, what the district was looking for in the way of testing, whether it's specific learning disability or maybe autism. Schools are supposed to have policies, and I don't think, and Colleen might be able to answer this too, I don't think they have to have, no, they're supposed to provide some type of list. And as I said, the school has to consider the outside evaluation. They don't necessarily have to accept it. So once the evaluation is done, then the team would meet again to consider the information. I always think it's best practice to have the person who did the evaluation present at the meeting and not just have the report. It's really, we always would have the person present. And, you know, generally what we try to do for the parent is to work with the school district to arrange payment so the parent is not necessarily spending out of pocket. So we would maybe be sure to arrange that the district is aware, and then they could just make that direct payment to the provider. But there are parents who go and get the IEE and then bring the bill back to the district.
Okay, someone wants to know, should districts have a special ed teacher as part of 504 plan?
Oh, I already answered that. No.
Okay. And here's one. If a parent requests independent eval, does school have to comply?
Yes. Mm-hmm.
Okay. And I think you answered this one too. If a parent wishes to change placement minutes in their child's IEP, does the whole IEP team have to meet, or would a written request change be suffice?
Yeah, I did answer that. Yeah.
Okay. Does no more than 10 days of suspension apply to students with 504 plans?
Yeah, I don't know. I'd have to look. Yes, I think so.
Thank you. Are there any other questions that we didn't get asked or answered today? And if not, I would like to say, Sally, thank you so much for your presentation. It was very informative. Hope to have you back again.
All right, thanks. I will stay on for a little bit because I don't have to go yet.
Good to have you. Thank you.
Okay, thanks.
We're going to move on to Colleen. And you
Hi.
may take it now. Thank you. Well,
All right.
Hold on just a moment. Let me go back because it's jumping again. Okay, here we go.
Hi, can you hear me?
Yes, we can hear you.
Excellent. So as Rita said, I'm Colleen McHugh-Moore. I'm the Director of Pupil Services for the Greendale School District, just starting my 10th year there. Much of what I'll speak on today will touch on things that Paul and Sally shared with you, and I'll talk about it from our school district's perspective. There will definitely be similarities, many similarities, between what Greendale does, how we apply these processes, and how other districts apply them. However, I always recommend that parents or people who work in other districts speak to their director, their teachers, and not rely solely on the way one district does it, because you will find some variations as well. So you can go to the first slide or the next slide. So the first thing I'll talk a little bit about is the child find process, and Paul did refer to this in his presentation. The public school has a responsibility to do child find for all of our residents, so that would include students who are homeschooled and all of our students who are attending Greendale. So that would include students who attend through the open enrollment process, or some of the Milwaukee suburban districts also have students attending through the Chapter 220 program, which is an integration program between Milwaukee and some of the suburbs. So they are all our responsibility. We do that in a number of ways. We provide public notices through our newspaper and through our annual newsletter, letting people know that if you think that you have a child with a disability, or you're aware of a child with a disability, you have the right to make a referral and have that child evaluated for special education, or to see if they have a special education need. We do something, this is something we do in Greendale, not all districts do this. We do something called Child Development Days. We just completed that last week, where we invite we send out a postcard to everyone in the entire community, letting them know that if they have a 3-year-old, 3 or 4-year-old who's not going to be going to school, that they can bring that child in, they make an appointment, and we screen them. We see how their development is, how is their language developing, their social emotional skills. They don't have to think that their child might have a disability. They can just bring that child in. Sometimes it's just very, very reassuring for parents of young students to have somebody else take a look, and sometimes it might lead to a referral for an evaluation. We also do grade level screenings within our district. That would be, for example, in Greendale, we use something called the STAR assessment. It's similar to MAPS. A lot of districts use MAPS, where we screen every student to see how they are doing for reading and math, for example. Now, I said all students, but there is some exception to that, because we have some students who, if they're going to be participating in the alternate state assessment, then we may make the IEP team may make the decision that that screening simply does not apply to that student. We also do Jumpstart. That's our 4K. We have a 4-year-old kindergarten program in Greendale, and that's a grade level screening where we bring students in, and it looks very similar to Child Development Days, but for our 4-year-olds. We also have a responsibility for child find to the private schools that are located within our public school district. We do that by notifying the private school administration that we are there, that we have a process for evaluating their students if they have a concern. We have an annual consultation meeting with the private schools, which will include myself, typically at least one of our school psychologists, maybe a speech language therapist, and then a representative from each private school. They are not required to attend. We are required to invite them. In Greendale, we have 3 private schools. One is very, very small, about not 9 or 10 students. They typically don't come, but we make sure that they know that we're available if they need us. We also do a review of student records of the private schools. In this case, we do ask the private school representatives to take a look at those files and see if they see anything in there that may indicate that the child has a disability or has ever been evaluated, and then we would take a further look. And we do also make sure that the private school is aware of the referral process. So we want them to know who the contact person is, the required information that they would need to give to us, which would be, we need a demographic information for the student, why they think the student may have a disability, and if there have been any interventions tried already and what those results were. We also do request a release of information form to be signed by the parent. I can't say for certain if that's a requirement, but we feel out of respect for the parent, we really do want them to know that the school is talking to us about their child and that they think their child might have a disability. So that would definitely be something to check with your district to see if that's something they do. Next slide. So let's talk about moving from concerns about a child to that actual referral process. There are some differences between what a public school will do and what a private school will do. Some of the public school processes are required and will look very much the same, or should look very much the same from district to district, and some of them are not completely specific from district to district. We are expected to do progressively intensive interventions unless something is so apparent to us that we would move directly to referral. Sometimes a student might move from, for example, another state, and it's very clear to us that the student is likely to qualify for special education, and we could go right to referral in that case. But for progressively intensive interventions otherwise, we'd start with things like classroom differentiation. Simple example, giving a student a choice of how they're going to demonstrate their learning. Maybe rather than a written work, they will do a project of some sort. We do small group targeted instruction. Example of that would be readers theater to help increase reading fluency. That could be a small group of students. We may do individual targeted instruction such as Orton Gillingham or specialized math intervention or specialized behavior intervention for a student. Those supports are provided by the classroom teacher or a specialist teacher such as the reading specialist, not the special education teacher. Throughout that process, we're reviewing the progress of the student, and we have what we call PSTs, a problem-solving team, or our high school calls it a SIT, a student intervention team. Virtually all districts that I'm aware of have something similar to that. And we're looking to see, are those interventions being implemented with fidelity? How is the student progressing? Do we need to change something along the way? The private schools don't have any of those requirements. It's really at their discretion. Many private schools, or at least that I'm familiar with in the Greendale, Milwaukee area, do have learning specialists of some sort, and they are able to provide support as they determine by that school. So it might be, they may have somebody who is going to provide some additional reading instruction or math instruction, for example. Those would be the most common types of supports they provide. That individual may or may not have a special ed certification or a reading specialist certification. That is really completely at the discretion of the private school. And it's certainly not a requirement, at least not to my knowledge. Also, the intervention teams are at the discretion of the school. Now, we really, in Greendale, we really encourage collaboration with our public school staff. So if they have a student, we work closely with a private high school and a private K-8 school in our district, and we offer our school psychologists, our special education teachers, our social workers. I've gone over and done observations of students so that we can try to problem solve with them, just like we do in our own district. It can be very helpful. Last year we had a specific example. There was a young child at the elementary school who was really having a difficult time behaviorally. So our early childhood special education teacher and our school psychologist and the private school learning specialist and the teacher met and gave some recommendations to help that student, and as far as I know, it was pretty successful. So we often have some strategies that they may not have thought of yet because of the wide range of students that we get in our public schools. Next slide. So as I said, we're monitoring that progress. The public schools are monitoring that progress frequently and making changes as needed and as appropriate. Inadequate progress will lead to a special education referral. There isn't a particular timeline. There are some pretty clear-cut guidelines if you're considering specific learning disabilities. And there's some very detailed information available for that if you'd be interested in. I would recommend that you go to the DPI website and look specifically at SLD. I'll talk a little bit more about it, but it'd be far more than we could cover in this morning. The private school, again, at monitoring of progress is at their discretion, and simply continued concerns lead to a special ed can lead to a special ed referral from them. I put a little caveat on the bottom, as Sally said. As Sally said, if we get a written referral for an evaluation, we have to respond to that. And so that would supersede everything that I've shared. This would be the ideal process. One of the challenges that we have when working with the private schools is that they may not have the understanding of special education eligibility and the high level of need that really has to be present in order for that child to qualify. Not having the range of students that we might have in the public schools, a child may appear to them to have a disability when in a public school they may or may not. So we may get a referral that we're not very confident that the student will qualify, but we certainly do go ahead and do a full evaluation. Next slide. So the evaluation process, I believe Paul mentioned this as well, is almost identical between a public school and a private school. So here's how Greendale does it. This would be an example of where we could definitely look a little different from whatever district you're representing. Every team will have a case manager. So in Greendale, for an initial evaluation, it's the school psychologist. For a reevaluation in the public school, it's typically the special education teacher. If it's a complex situation or perhaps a new special education teacher, the school psychologist may still decide that it's in the student's best interest to case manage it. But typically the special ed teacher. The reevaluation for a private school will be the school psychologist or speech language therapist, and I'll touch on that a little bit more later. In Greendale, the service we provide to the private school is speech language. There will be special education staff, of course, whether it's public or private, and that would be specific to the area of concern. The regular education teacher of the student, or if the student is not school age, we would have a preschool teacher present. Greendale does have 4K, so that works quite well for us. We have one of our 4K teachers each year takes on the role of being our official preschool regular education teacher. Other districts may have to figure something else out in that regard. And then the public school, we call it an LEA rep. That's typically an administrator, school psych, social worker. You can see that list. People can do a dual responsibility, so our school psychologist can be the school psychologist and the LEA rep at the same meeting. That definitely varies by district. Some districts have to allow teachers to be the LEA rep and some don't. And then the private school administrator, we strongly encourage the administrator to attend, but they are not required to attend the meeting. Some districts do have diagnosticians who do all of the evaluations. And then the one thing that I didn't put on here, and I certainly should have, is that parents are part of the team for public and private. They're part of all of the teams, whether it's public, private, homeschool, any of the above. So how do we determine eligibility? The next slide. So Paul mentioned these two questions. Does the student have an impairment, and does the student require specially designed instruction? There are actually 11 impairment areas in the state of Wisconsin. The criteria is the same between public and private, except for specific learning disabilities. The public school specific learning disability criteria is insufficient progress with intensive interventions. That intensive intervention process is what's laid out quite clearly in the regulations, but it includes documenting the interventions, documenting the response to the intervention, determining if the rate of improvement is appropriate for this to close the gap, and determining if the intervention is sustainable within a regular education program. So it's quite involved, and it requires a great deal of progress monitoring and very targeted instruction. The private school specific learning disability does not require that level of intensive intervention or the requirement for research-based, scientific or research-based intervention. None of that is required for the private school. We use what's called a discrepancy model. That is what the public schools used to use until, well, I don't know, 2013. It seems longer ago than that. And the discrepancy model, just simply put, is we get an intellectual ability level, so an IQ for a student, and then we do norm-referenced academic achievement assessment, and there is a formula, we have a chart we look at that tells us if a student has an IQ of, for example, 100, which would be exactly average, they should be performing around that mark academically. If there's a significant difference, that student likely has a learning disability. That's what we use at the private schools. And then both public and private, there also has to be an inadequate classroom achievement delay. So a student, for example, with a very high IQ may not be performing at that expected academic level, but may be performing quite fine as far as classroom achievement goes, and that student then may not end up qualifying. But again, that would only be for the private school. Then the second question is, does this student require specially designed instruction? That means, does this student need something that cannot, even with modifications or accommodations, be provided through the regular education programming? And it's important to note that programming and location are not the same place, are not the same thing. So a student may need a quiet environment for test taking, for example, but is going to take the same test as everybody else, needs a different environment. That's still regular education, it's just a different location. Next slide. So after we've determined if a student is eligible for services, we have to decide what those services will be. In the public school, a student is entitled to what we call FAPE. It's a free, we can't charge the family. It has to be appropriate to that specific student. It's obviously through the public schools and the education they need to advance in the general curriculum, or for students who are in alternative programming or alternative curriculum within that. We do that through the IEP plan. We develop that very individually based on their unique needs. And that can be anything from a few services to very extensive services. So few services might be 30 minutes of speech-language therapy per week. We could have extensive services that could include multiple hours of specially designed instruction and support throughout the day. We have some students who have, while we don't want the adults sitting side by side next to the student, there is an adult in the classroom on behalf of that child at all times. So there's really a wide range of what a student might receive. So equitable services has been mentioned, and just briefly, how we determine equitable services. It's really an equitable funding component. We take the total number of special education students identified as receiving special education services or eligible for special education services all together between the public school and those that we are aware of in the private school. We divide out our federal funding. So if we have 300 students all together and we get $600,000 of federal funding, we divide that out and it says this is what each child roughly, you know, what you'd be allocating. And then we take the number of private school students, and then that percentage would be what we have to spend on their services to the private schools. So that's how we figure that out. I think it's a little easier than what I just tried to explain, but they get a percentage of our federal dollars. So that's then what we work with to say, well, what are we going to give? What makes the most sense for the public school to provide to the private school when this is the amount of money that you're entitled to? It's not an individual student right. We consult with the private school representatives and we say, well, here's what we have. Here's what we think we can. Here's what we suggest we provide to you. We hope that we can come to agreement with them, but ultimately the district determines what's going to be provided. And then we develop a plan of service for the students if they're eligible and if their need aligns with what the district has decided is going to be provided. And I'll explain that a little bit more on the next slide. So an IEP, and I would imagine that most of you are familiar with IEPs. You know that it addresses all areas of impairment, and there are many, many services that we can consider. I put a list there of some of them, but that's certainly not exhaustive. For the plan of service, again, it's contingent on that equitable service plan. So what the district has determined that will be the best use of that money that has to be allocated to the private schools. What we provide is speech language services for the kindergarten or K4 through 8th grade students at the one private school. That is not an uncommon way for districts to do it. And the rationale is that it's what we consider a way to get the most bang for the buck. We could say, well, we will send over a special education teacher an hour a week for a student who has a learning disability, but that's really not going to have much impact on that student's progress. The speech language therapy, we can typically provide the same amount that child would get if they were in a public school. We choose to provide those services at the private school. So we send one of our speech therapists over to that school, and she works with the teachers and the administrator there very similarly to if she was in one of our public schools. That's how we feel is the best way to do it. And then the 9th through 12th grade students do not receive any direct services. And as I said, that the level of what they get has been agreed upon. That level of service will also be a maximum agreed upon or whatever is appropriate to the child. So if we say, well, we'll provide up to 90 minutes of speech language therapy per week for a child, but this child only needs 45 minutes, then that's what the plan would include. All right, next slide. I think, oh yeah, okay. All right, so now we're going to talk a little bit about, we're going to move on from special education and move on to Section 504 and what that looks like in our school district. As has already been talked about, that a student must have a physical or mental impairment that does not rise to the level of needing special education. Now, Sally said that she advises that a special education evaluation is always done. I would say that many of our students who end up with 504 plans have had a special education evaluation, but sometimes there are students who we can see quite certainly that this child isn't going to qualify for special education, but a 504 plan appears to be appropriate. For example, we had a young student who had a mild cerebral palsy, and used, I believe they're called AFOs, but braces on her foot and ankle. She simply needed somebody to be trained to make sure that those weren't chafing and that she was putting them on correctly. That was all she needed. So we did a 504 plan for that, and our physical therapist trained the classroom teacher and the physical education teacher. So that one was a pretty clear cut. Other than that, she was quite successful in school, and we just wanted to make sure she was safe and comfortable. So it requires a 504 plan requires accommodations to remove barriers. Often we'll call that just leveling the playing field, trying to make sure that everybody has equal access to their education. As has been mentioned, there is no clear-cut criteria or clear-cut processes, which can make it quite difficult for school districts to determine, does this child qualify, does this child not qualify? It may be why when you're out working in your districts, you may see some discrepancy between one district and another, because we are trying to determine how we apply the law and make sure children's rights are protected. Many districts that I'm aware of, and Greendale is one of those, of course, we follow the IDEA. We just follow that IDEA process from start to finish. So we do the interventions, we try interventions first, we'll make a referral, evaluate to determine eligibility, and then if they're eligible, we develop that accommodation plan. We do our reevaluation every 3 years, just like we do for IDEA. Next slide. So what's in a Section 504 plan? Well, they're accommodations. So they don't change the essential elements of the learning targets and expectations. They're simply strategies that will help the child reach those. So some examples would be extended time on assignments or tests. A child might need help with getting organized, especially we have students who have difficulty with long-term projects where they're going to be doing it over the course of a semester. So we may realize they need that broken down and somebody to be checking in with them more frequently. Enlarged print, audio breaks, and so on would be examples of accommodations. Who implements it? As has been said before, it is implemented through regular education staff. In Greendale, of course, that's our regular education teachers, or the school psychologist. It could be a guidance counselor, the school nurse, etc. In Greendale, school psychologists or social workers are the case managers for elementary school. Our school psychologist also will case manage alongside the counselors at the high school, and at the middle school, it's a school counselor. They are the case managers. We don't ask classroom teachers to do that. The classroom teachers have to be aware of the plan and be implementing it. The next slide. They both provide protections to students, as Sally mentioned, for example, disciplinary issues leading to expulsion, for example, that we have to do the manifestation determination. And my understanding is because 10 days of removal for suspension is considered a change in placement when you get past that 10 days, we would certainly do a manifestation determination in Greendale if we were getting to that point. Everybody is strongly encouraged to let me know when we're getting close to 10 days so that because clearly if we're getting to 10 days, something's probably not quite right with the plan and we need to reconvene. And then of course there's one of the protections is that parents have the right to have input into both of those plans. Private schools may or may not be eligible for a Section 504 plan. As Paul said, they have to be receiving federal funding, and I don't know as a director whether they are. I don't know if a given school is receiving federal funding or not. Even if they are required to do one, it would be at a lower level of accommodations that would be expected or required, that according to the little bit of research that I did prior to today. And my understanding has always been that the process is solely the responsibility of the private school. However, based on what Paul said today, if we would get a request from a private school, I'll be calling the Office of Civil Rights to find out what they advise. I must have spoken to whoever told him we should not be doing them. So I would have to look a little further into that. Next slide. The last thing I'm going to touch on just a little bit is the special needs scholarship that you might have been hearing about in the news. And it's something that we're all learning about together. There will be some changes coming that we'll be sorting through. But it's for students with a special education identification who are in a private school that is a participating private school. Not all private schools have made the choice to participate in this option. There is a list available on the DPI website. The funding comes through the resident district. So no matter where the school is located, the money would flow through the resident district. So in Greendale, we have a lot of students going to our private schools who live in Milwaukee, for example. So if those students would be eligible for a scholarship, that money would come through Milwaukee, and it has to do with adjusting the tax levy, is my understanding. That would be a question for the business department, however, not for me. The impact on Greendale so far really has not had a significant financial impact. We don't have many students with disabilities who choose to go out to the private schools. What has changed is that the private school, especially the high school, because they are a school that's participating and they are a voucher school now, they have had an increased number of special education students attending their school. So we've had an increase in students already identified who are now attending that school, and an increase in referrals. So I would say that has had an impact on us in that regard. We have not had a financial impact. There are some proposed rule changes coming in the new budget, as I understand it. Currently, the total amount is $12,000 is the scholarship, regardless of how little or how much service this child needs. My understanding is that that's proposed to be changed to cover the actual costs. And there also was a requirement that the student had applied for open enrollment and had been rejected. I believe that that is also being removed. So there are some changes to be watching for. All right, that is really all that I have for you today. So are there any questions for me?
Thank you, Colleen. We do have some questions on the board, and let's see if I can get those open for you. Let's see here. Okay. Okay, these questions, I'm not sure what the format they're in. Can you all see the spreadsheet here?
I can't see a spreadsheet, but I can see a list of questions.
I can see the questions too.
Okay.
This is Evelyn. Rita, what I've been doing is taking the questions and putting them into the chat and addressing it to the organizers and panelists, so you guys would have them there as each person wrapped up.
So I do see one question on here, so I could go ahead and read the questions that I see if you'd like.
Yes, please. Thank you.
So is the IEE for private schools as well? That's a great question. The evaluation, the child find process and the evaluation process is not considered part of equitable services. So those rights going up through determination of eligibility are the same for public and private. So a private school parent, as far as I'm aware, would have the right to request an IEE because it's tied specifically to the evaluation. Now, if there was something else, as Sally said, sometimes somebody might request an IEE for a functional behavioral assessment. Well, that's really not part of the evaluation process itself. So that in that case, I'd have to get additional guidance if that was asked of us. But for determining eligibility, let's say we don't believe that this child is eligible because their reading scores are too high. And a parent says, I don't agree with you that they're too high. I'd like an IEE. Yes, they would be eligible for that.
This is Sally too. I do think that could come into play now, possibly more with the changes to the special needs scholarship. So something to be looking at is if students are in private schools and they want to get that funding, they could get an evaluation from the school district, but if they're not determined eligible, they could fight that with an IEE.
Right, absolutely. And I think what we often run into with the private school evaluations, if the child is successful and passing their classes and doing all right emotionally and socially, they're not getting any, by definition, they're not currently receiving any special education, and they're being successful. So I could absolutely see that happening more often now. The next question is, does anything for gifted learning go on any of these plans, or is that a separate concern? That would be a separate concern. It would not go on any of these plans. Districts will have gifted and talented plans for their students identified as gifted and talented as they determine. In Greendale, that the responsibility of overseeing the GT programs falls under the curriculum director. In some districts, it would fall under my counterpart, the pupil services director, but it definitely is not on a 504 or an IEP. Let's see. If there's a position open within the district for PT, OT, or speech, what is the responsibility of the district to fulfill these services? The district has to continue to make every effort to fill those positions. They can be very difficult positions to fill, however. So what we've done, for example, in Greendale, when we've had a time where we had difficulty filling the positions, we'll work with third-party contractors such as CISA, or there are private companies that also will try to find somebody for us. We will we'll advertise to all of our other director friends to see if anybody knows of a retired individual. We have offered to parents that we would work with. For example, we have a company in our area called New Berlin Therapies, where if they would be willing to take their child to therapy there, we would pay for it and reimburse. So, and ultimately, if we can't get that filled, my understanding is then we would make up those minutes when we do get it filled. Sally, is that how you would respond to that as well?
Yes, that's what we've seen. You know, we've definitely seen speech therapists too. So, and we would encourage districts to try to figure out a solution, even if they have to go use the parent's private provider for a period of time.
Right. In fact, we ran into that this summer, where I was having great difficulty finding somebody to do extended school year services. So we had actually contacted the parent who reached out to the private provider. In the meantime, I was able to fill it, actually through CISA. So, but yes, we have to be very creative at times, but we can't just abdicate our responsibility because we can't fill it. Okay, let's see if I can see another question. Can parents request more services be added in an IEP, such as more PT, OT, and speech? They certainly can make that request. If the school district doesn't agree with them, if they agree, they can often make those changes without an IEP meeting, as long as placement isn't being changed. If they don't agree, the team would reconvene and discuss why the parent feels more services are needed, what aspect of the student's IEP is not being met, or whatever their concerns might be, and hopefully come to consensus about whether or not more time is necessary, and if so, how much. Of course, if they don't come to consensus, if they can't reach an agreement, the district makes the final decision, and then the parent, of course, has the appeal rights that have been discussed earlier. What are a family's rights if the district refuses to pay for an independent eval? Well, provided that the parent has gone through all the appropriate steps to get that independent eval, I would imagine that the parent would certainly have a right to, the first thing I would say is contact DPI and probably file a complaint to be reimbursed. Let's see. Okay. Okay, I think that might be it. It looks like the rest.
I think there was a question about parents, about RTI, and it looked, you know, that yes, parent requests supersede that, but you know, you need RTI to still have an appropriate evaluation, right?
That's correct. So what we would run into, so RTI is response to intervention. So that's that intervention process that I was describing very briefly, where we have to first implement, particularly if we're considering SLD, we have to first implement those intensive researched or evidence-based strategies and be monitoring that progress. And we have to try at least 2 per the state regulations. If a parent makes a written referral, we would start the process, but we will get to a point where we can't continue the process until we've had the opportunity to complete the intervention cycles. So it would be, we would need additional time to complete it. Okay, let's see. Other questions on here?
The only other thing I was going to say is you brought up the special needs scholarship, and so I just from a policy perspective, you know, it's still at the, they have made those changes where parents they don't have to have an open enrollment denial, they don't have to have been in a school year for the previous year, so it could be kids who are in private schools already. And the funding is going to pretty much be whatever those costs are, but it's based on whatever the agreement is between the parent and the private school. So I guess what you say is the IEP could be amended, even though it's really not put in place. So it is an issue right now, and you know, there is a possibility if that's something parents are calling about, you know, we still have an opportunity that the governor could veto that out of the bill. It does become an issue for public school funding. In our state, we've not had an increase in special ed categorical aid for almost a decade. So it does pull more resources out of our public schools. So that can, you know, that's definitely a challenge. And then there was another question, I can't remember what that was.
I just saw one about rejecting open enrollment. Can a school district reject an open enrollment school district change because of an IEP or 504 on record? If the child can change district, is he eligible for all services? Okay, so a district can't reject an open enrollment application because of a 504 plan. For an IEP, if a student has an IEP, when they apply for open enrollment, when they apply for open enrollment, the district has to consider, and actually we make this consideration before the open enrollment application period begins. So in January, we make the determination of how many regular education seats we have available and the space we have available in our special education programs. So we do that by caseload. There has to be a seat available in that child's grade level for regular education and space available for what that child needs in his or her IEP. Even if that student is one who would, I've had parents who have said, my child's not going to be going into the regular education classroom because of his IEP. That's not part of the consideration. There has to be a seat available in both regular education and special ed. So if not, the student would be denied a seat for one or both of those reasons. And then they can appeal to DPI if they think that the decision has been what is called arbitrary or capricious. Does a district have certain protocol to follow when the decision is made to involve law enforcement in a school for a behavioral issue? Do the parents need to be notified first? There's no requirement that districts have a protocol I would imagine that most districts do have a protocol, and they do not need to be notified first. It really depends on the situation, and typically we would call the police, for example, in Greendale, if the student's behavior is such a danger to self or others, and we're not able to keep that child or other people safe, even if we're using a restraint. The other may be if there's been a legal violation, a drug possession, student being at school under the influence, of theft. The same kind of things that you might think that other people would call the police for would be what a school would call the police for. We certainly do notify the parents, but it's not always beforehand.
The other thing is there's some new resources on the DPI website under school resource officers. I was part of a stakeholder group where we worked on a memorandum of understanding and some best practices. So that is another area of information that you can find on DPI's website. The other question that I remember now was about 504s at private schools. So private schools do not put 504s in place, but they do have to provide reasonable modifications to programming for students with disabilities.
That makes sense. So that would be things like, you could think of some of the obvious things like accessibility. If a student could otherwise participate, but is in a wheelchair and needs a ramp, something like that, they would most likely have to comply with that.
Or even extra time on a test, or, you know, I guess I would say very simple accommodations.
Yes. I don't see any other questions. Does anyone else? I'm just scrolling through one more time. I think we've covered them all.
Yeah, I think so too. Thank you so much, Colleen, for putting things into practice for us and showing how the process from a special ed director position. It was very helpful, and we had a lot of questions. Thank you for answering them. And we're almost done with our training on today. It looks like we're going to end a little bit early, so we just want to show you all some resources that you can connect with, understood.org, of course, the Wisconsin Department of Public Instruction website, and then this URL here with the 5 handouts link is available as well. So just to review what we covered today, participants talked about the difference and similarities of IEPs, 504 plans, and service plans. Participants also heard from a variety of perspectives, and we learned about resources to share with families who have a child with a disability and school staff who work with them. If you would like to contact any of our presenters, we have Paul Sherman, Colleen McHugh-Moore, and Sally Flashberger's email address. And last but not least, thank you all for your time and participation. Have a wonderful day. Bye-bye.